So we just wrapped up day 89 of the YSL RICO trial, and I'm super interested in it because it's a ton of attorney sparring. And now, thanks to Joseph Papp through AJC, we have an emergency motion for Supersedeas bond on criminal contempt. So let this man, Brian Steele, get an appeal bond. We're going to read it. So comes now movement Brian Steele, hereinafter Mr. Steele, by and through undersigned counsel, and files this emergency motion for supersedeas bond on criminal contempt charges pursuant to Court of Appeals rules. In support of this emergency motion, Mr. Steele shows the following. 1. Mr. Steele is lead counsel of record for Jeffery Williams, that's Young Thug, in the state of Georgia versus Jeffery Williams et al. And that indictment is a 65-count RICO indictment charging 28 individuals. The jury trial of multiple defendants commenced on November 2023 before Fulton County Superior Court Judge Ural Glanville. The trial is expected to last through the end of the 2024 calendar year, and probably longer than that. On Monday, June 10, 2024, the trial judge, along with the state prosecutors, engaged in an ex parte hearing with a sworn witness, Kenneth Copeland or Woody, for whom an order of immunity from state prosecution had been issued. No notice of an ex parte meeting involving the state and the sworn testifying witness was provided to any attorneys for any of the defendants in the case. The witness had previously been called to testify on Friday, June 7, 2024, asserted his Fifth Amendment privilege in open court at that time, and was held in contempt and summarily incarcerated until such time as he agreed to testify for the state pursuant to the grant of immunity. Judge Glanville and the prosecutors admitted in open court that an ex parte meeting occurred on the morning of June 10, 2024. There's a footnote. A transcript of the relevant proceedings on June 10, 2024 has been ordered from the court reporter. A video recording of the entire June 10th trial can be accessed at YouTube. When the trial reconvened on June 10, 2024, Mr. Steele informed the court that he and others had learned, based upon information and belief, that an ex parte meeting with the sworn witness, Kenneth Copeland, occurred earlier in the day. Mr. Steele proffered his understanding that the witness had made factual admissions to criminal conduct. Very serious and relevant criminal conduct, if I might add, which the state intended to use against Mr. Steele's client in its case in chief, and that statements were made to the witness about the amount of time he could be held in custody on the contempt. After the court acknowledged the fact that the meeting had occurred, Mr. Steele demanded information regarding the meeting, including the names of everyone who was present, requested a transcript of the proceedings, and made a motion for a mistrial on the grounds that an improper ex parte hearing was conducted with the sworn witness, Kenneth Copeland. And they cite the Uniform Superior Court Rule 4.1 and the Georgia Code of Judicial Conduct 2.9 delineating rules. So the motion continues that this ex parte meeting violated Mr. Williams, Young Thug's constitutional and statutory rights, including the right to due process and a fair trial. The trial court rejected Mr. Steele's substantive request for information about the ex parte meeting, and the court denied Mr. Steele's motion for a mistrial. However, the court instead demanded to know how Mr. Steele came into possession of the information about the ex parte meeting. That was Judge Glanville's main concern. Citing State of Georgia Bar Rule 1.6, confidentiality of information, Mr. Steele declined to provide that information requested by the court. And Rule 1.6 states, in pertinent part, that a lawyer shall maintain in confidence all information gained in the professional relationship with the client, including information which the client has requested to be held inviolate or the disclosure of which would be embarrassing or would likely be detrimental to the client, unless the client gives informed consent, except for disclosures that are impliedly authorized in order to carry out the representation or are required by these rules or other law or by order of the court. Comment 5 to Rule 1.6 specifically states, and this part in bold here, the attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of client-lawyer confidentiality applies in situations other than those where evidence is sought from the lawyer through compulsion of law. Rule 1.6 applies not merely to matters communicated in confidence by the client, but also to all other information gained in the professional relationship, whatever its source. A lawyer may not disclose such information except as authorized or required by the Georgia Rules of Professional Conduct or other law. The court repeatedly demanded that Mr. Steele reveal the source of his information, claiming that the way Mr. Steele obtained that information was, quote, unlawful. We saw that same phrase quoted in the other motion we read this morning, and baselessly accused Mr. Steele on the record of potentially acquiring the information through, quote, eavesdropping. In response to the accusations and the demands of the court, Mr. Steele relied on the ethical mandates of Rule 16 and the Fifth Amendment right to remain silent when accused of a crime and declined to provide the source of information which had been proffered. The court held Mr. Steele in criminal contempt for refusal to provide the source of the information regarding the ex parte meeting, and the court ordered that Mr. Steele be taken into custody until such time as he revealed the source of the information about the ex parte meeting. The court did not enter a written order at that time. The court thereafter permitted Mr. Steele to participate in trial for the balance of the day, but indicated that at the close of business, it would again address the contempt matter and demand that Mr. Steele reveal the source of the information regarding the ex parte meeting. At the end of the trial day, the court again took up the issue of the contempt and demanded that Mr. Steele reveal from whom he learned about the ex parte meeting with the sworn witness, Kenneth Copeland. Mr. Steele again declined to disclose this information, citing the relevant privileges. The court reiterated that it was holding Mr. Steele in criminal contempt and that he could only purge himself of the contempt by informing the court from where he obtained, quote, information that he shouldn't have had. Mr. Steele informed the court that members of the Georgia Association of Criminal Defense Lawyers were outside the courtroom, seeking to represent Mr. Steele. Undersigned counsel, attorneys Merchant and Souzer, were ultimately permitted to enter to represent Mr. Steele, but only after the court had already recommenced further discussion of the contempt issue with Mr. Steele without his legal representation behind him. Following arguments on the issue of contempt, the court issued a written order of contempt and incarceration for Brian Steele, finding him in direct criminal contempt and imposing a sentence of incarceration for 20 days. So they attached the order. The trial court ordered that Mr. Steele was to begin serving his sentence at 7 p.m. this Friday, June 14th, 2024, which necessitates the instant emergency motion, so we need this speedily. The appeal that will follow will address 3 issues. First, whether the court abused its authority in presiding over the very contempt hearing that was born of allegations that the court itself had violated the rules governing ex parte communications. Second, whether the court denied Mr. Steele's due process rights during the conduct of that hearing. And third, whether the court abused its authority in holding Mr. Steele in contempt for refusing to divulge privileged information and for protecting his client's constitutional rights to due process and effective assistance of counsel. Regarding the first issue, the court had a duty to recuse from presiding over the contempt proceeding, in such proceedings where the announcement of punishment is delayed and where the contumacious conduct was directed toward the judge or where the judge reacted to the contumacious conduct in such a manner as to become involved in the controversy. The judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. Here, the court involved itself in these proceedings by conducting the ex parte hearing that violated Mr. Steele's client's rights. This created a conflict of interest for the court because its own ethical conduct was at the heart of Mr. Steele's request. The court then compounded its abuse of power by presiding over the very contempt hearing where its own rule violations prompted the controversy. The court should have recused and allowed the contempt proceedings to be handled by a separate court. As to the second issue, referenced above, the court denied Mr. Steele his due process rights as Mr. Steele has a right to adequate notice and to be heard, to call witnesses at a hearing, and to be represented by counsel for the entirety of the contempt proceeding. As to the third issue, referenced above, an attorney may only be held in contempt for statements made during courtroom proceedings after the court has found that 1. The attorney's statements and attendant conduct either actually interfered with or posed an imminent threat of interfering with the administration of justice. What do you guys think about that? Did that occur? Did the court find that Brian Steele did that? And 2, that the attorney knew or should have known that the statements and attendant conduct exceeded the outermost bounds of permissible advocacy. Because contempt is a crime, the evidence must, of course, support these findings beyond a reasonable doubt, so there's a high standard that the trial court needs to support. When addressing contempt matters, any doubts must be, quote, resolved in favor of vigorous advocacy. In other words, if Steele is arguing that what he's doing, what he's saying is privilege, what he didn't want to divulge to the court at the court's request, if it's unclear, if there isn't case law that explicitly outlines which way this should be decided, lean in favor of resolving it in Brian Steele's favor. The Supreme Court has emphasized that, quote, courts must be judicious in their approach to adjudicating contempt precisely because vigorous advocacy is essential not only to the preservation of individual rights, but also to the integrity of the judicial system, whose truth-seeking process is sought to be protected through the exercise of contempt power. Accordingly, the court should always assess whether there are correctives sufficient to address the problematic conduct in question. Therefore, trial judges must be on guard against confusing offenses to their sensibilities with obstruction to the administration of justice. Yeah, I think we had a little bit of offense to sensibilities going on Monday. What do you guys think? You're allowed to disagree. You're also allowed to agree. Mr. Steele's statements and conduct did not interfere with or pose an imminent threat to the preservation of order and decorum in the court, or interfere with the orderly processes of the administration of justice, as evidenced by the fact that the court was able to continue the trial after its initial oral pronouncement holding Mr. Steele in contempt. Further, Mr. Steele's refusal to disclose the name of the individual, and in parentheses they put plural, so they're not saying it's just one person possibly, they're letting it be open in the air, who informed him of the ex parte meeting, which he argued would constitute a direct violation of his duty of confidentiality imposed by Rule 16. And it goes on to continue that refusal in no way delayed or impacted the underlying trial. Moreover, any doubt must be resolved in favor of Mr. Steele's vigorous advocacy on behalf of his client, especially when he was raising serious concerns about the court's involvement in an ex parte contact with a sworn witness. A notice of appeal and motion for a supersedeas bond have been filed in the trial court, and the court orally ruled that it would not grant a bond. Pursuant to Rule 40b-2 and 3, a stamped filed copy of the trial court's order finding Mr. Steele in contempt is attached as Exhibit A, and a stamped copy of Mr. Steele's notice of appeal is attached hereto as Exhibit B. Pursuant to Rule 40b-4, Mr. Steele shows that the service is being perfected upon the state of Georgia and the trial court contemporaneously with the filing of the instant motion. Finally, pursuant to Rule 40b-5, the instant filing is being accompanied by the filing fee as required under Rule 5. So this paragraph is showing all the administrative checkboxes. We've checked them all off. Everything's here. We've given you the notice to appeal. We're giving you evidence to make our case for the appeal that you should think is sufficient to move forward. And we've paid the filing fee. So wherefore, Mr. Steele files his emergency motion for bond and asks that this court order that a supersedeas bond be granted pending the appeal of this contempt finding and that the imposition of the sentence be stayed. So that's that, and that came from Joseph Papp with AJC, and it was filed by several attorneys, including Ashley Merchant, Colette Resnick Steele, that's Brian Steele's wife, and Alex Souser. That was the guy with the ponytail that we saw standing next to Ashley Merchant, making their arguments on the floor of the court in front of Judge Glanville on Monday. So what do you think of this motion? And now that there's a notice of appeal, if there is a full appeal file, do you guys want to look at that too? Let me know. Let me know your thoughts on everything that we just looked at here. And you guys take care until next time. Bye.